Okay, I think I fixed it. Do you have me? Am I moving? Am I in motion? Hey, everybody. Welcome back to Resource, real talk about Louisville real estate. I'm still Gabe Pruitt.
And I guess I'm Jay Pitts. Am I on the camera? Hello.
Yeah,
We're here.
We got it.
I just had
season 3 has been a doozy so far.
I just had a lot of fun watching the outtake from last week's live episode.
In the group, yeah.
In the group where we clearly did not know what was happening, what was going on. Yeah.
I think next week we will, I think we'll just go ahead and bend this and we'll start season 4 next week. Just get a fresh,
Well,
start.
We're still not live in the group, so I'm really not sure what's happening.
Well,
but
yeah, we're live. We're live and we are in the group. It's just taking a while to show up on your screen.
What is Facebook doing?
You might just have to refresh. It's nice.
Neither here nor there. We are here. We are here. We are here.
Yep, absolutely. So today we just got out of a tactical training session with our team, right? This is in the spirit of season 3 and what we were talking about towards the end of season 2. This is the not only the tactical, but also the hyper-local focused season of Resource. And in that spirit, we were talking about something that affects a lot of agents here in the Louisville market, which is some changes to the board contract that all of us use as of January 1, 2020, right? So we've been talking to our agents, making sure they're prepared and understand what they're reading so that they can effectively communicate it to their clients. But wherever there's change, there's also controversy, right? So we wanted to take a little bit of time today to break down some of the changes, some of the things that are popular, some of the things that are not very popular, and maybe hypothesize what other changes might be around the corner as they fine-tune this.
Yeah, no. Anytime there is change, there is much to do about usually nothing. I mean, like, are we really going to change the way that we operate? I don't know. I mean, I think to a certain extent there will be some changes. Marcy, will you grab me my notes sitting over there, right there on top of those books? Hand them to me so that I am prepared to discuss.
Oh, perfect.
Of course, I left
Source
them across
material.
the room. Source material is required. But yeah, we've got a new contract. We've got new reg changes. We got a bunch of new inspection stuff that we're hearing about. So what does all that mean?
Yeah.
I mean, it means that A, you need to pay attention to it. B, you need to set proper expectations like we always discuss here on Resource. The key to conflict communication is expectation setting.
Right.
Up front, prior to expectations coming to fruition. So we talked about today on a side note the concept of pre-framing and future pacing, which are sales tactics,
right,
which essentially speak to expectation setting. It speaks to handling an objection with a client in a sales environment prior to the particular challenge being raised.
Foreseeing a challenge.
Yeah, foreseeing a challenge or an objection in a sales situation.
And then setting the stage in a favorable way for you.
Exactly. Yeah. So, for example, there's some implications with respect to chimney inspections and termite inspections. Future pace. Pre-frame those issues with your sellers when you sit down prior to taking a listing so that they know, okay, what to expect when it arises, if it arises, and you're going to be that much ahead of the game, ahead of that agent that doesn't do those things. Okay, so there's some other things. Another concept that we have to understand as a reality of law, legal, different, standards of practice and that kind of thing is that there are always unintended consequences.
Yeah.
The root of these issues, Gabe, is the fact that our industry has moved in a direction where they've played fast and loose with certain laws and regs.
Okay.
And the consequence is regulators, i.e. state government or the national, state and local association of realtors,
right,
wondering if the consumer's best interests are being served and enacting regulation, statute, or policy based on their fear that the consumer is being deceived.
Okay.
So everything, advertising changes, everything, disclosure issues, it's all rooted in worrying about the consumer.
Yeah.
Okay. They wouldn't have to worry about the consumer if our industry didn't play fast and loose with respect to these topics.
Well, and speaking of that too, it's important to get down to, I think, different conversations are happening in different offices around the city this week about these regulation changes.
Right.
And a lot of it is, you're going to hear talk that a lot of this stuff is really minutia that you don't need to concern yourself with. Some people maybe aren't really thinking about the implications of these chimney inspection changes and termite things. The last thing you want, though, is to be in a situation with a seller where one of these things ends up causing a problem, and then you have to tell them, oh, I didn't know. Because your sellers and your buyers, they don't care or know or care to know that this just changed in January. To them, you should be an expert who knows the contract. And if you don't know it, it's like you never took the time to learn. So you can't just say, hey, it just came out a month ago. I haven't had a chance to sit down. They're like, in a month? For this contract that affects me? You haven't had a chance to look over it? So it's very important, even when you think this doesn't apply to you, to understand. And as obviously, it gives you an advantage, too. If you can, like you said, future pace and listing appointments, say, hey, a lot of agents in town aren't going to point this out to you, but this is a big change that just happened a month ago. And I know that the chances are slim, but this could affect you. And then when Agent 2 and Agent 3 come and interview and they glaze right over it, you have sellers going, wow, he knew that and they didn't. So.
Well, you're future pacing the problem. What I tell the agents in that meeting, I said, you're basically you're setting a landmine for the next agent to step on.
It's a perfect analogy.
Okay, like when you come in and you talk about regulatory changes, the expectation is that you are the professional. You are the one that has their finger on the pulse of what is happening in this industry, not the consumer, because they read, Yahoo Finance.
Yeah.
Right? Like you're the expert, and when you know that the education level and the level of expertise bar is set really low in residential real estate, and you go before a client and you talk about this, just like Gabe says, this happens, then they ask the next guy, and it is like all over their face, the level of surprise. Because the truth is, I talked to a really good agent not that long ago, and they were surprised to know that we've already had 2 classes. I've had a small group meeting with some of our most productive agents in the brokerage about these implications. That's what you get here. And this is not a commercial for our brokerage. But the truth is if your broker's not giving you this, you need to demand it.
Sure.
They need to understand. They need to bring in professionals. They need to have an opinion themselves, because let's be frank, Gabe, and I'll make this as public as anybody wants to debate me on. There's some of this stuff that I don't plan to comply with. I think it speaks to the root. I think a lot of it is not, and I don't mean the regs or the statutes. You got to follow the law.
Yeah.
Okay, but a lot of this is in
some of it's recommendations.
A lot of this is in the spirit. Okay, and there's unintended consequence that the lawmakers have not considered. The leadership at our local board has not considered. There's some verbiage in here about how, because they're trying to eliminate the gray area on binding electronic signatures, we have now adopted a standard that basically means that anything communicated electronically with a name attached to it.
Okay.
Explain to me how you can communicate electronically without your name attached to it, and I'll.
It's kind of a given.
I'll ponder that. But anything with a name attached, the name is construed as the signature and can be argued as binding.
That seems really weird to me, but I'm not a lawyer.
So there's a 63-word disclaimer that is to be used within email communication. It's very easy in terms of execution on email. We have one. Seriously, Gabe, I could pull it up right now. It's a lot longer than 63 words. We have a disclaimer already in our email signatures.
And the purpose of it is to do what, right? It's to indemnify us from...
Yeah, it's to indemnify us and make a blanket statement about
none of these electronic conversations are meant to be binding.
No. It's not. We don't address that. We don't address that yet. Okay. We're going to address that. That is a change that we're adopting. But we don't ask for wiring instructions. We don't ask you to transmit non-public information via email.
Yeah.
Like there's some disclaimers in our email communication already, right? We don't ever ask you to wire us money over email. That's not going to happen. There's too much opportunity for fraud in that circumstance.
Right.
But this verbiage is going to be added. But the recommendation is to add it to your text messages too.
So does that mean every text?
You tell me.
At the beginning of a conversation?
Gabe,
or
who is your potential client?
Just about anybody.
Okay. Who would you potentially text? Just about anybody.
Anybody.
So are you potentially communicating with a client anytime you send a text message?
Does it count if I'm potentially communicating with a potential client?
Yes.
So
it does count.
So basically what this is saying is you should disclaim
every single text message.
Basically, whenever you talk to someone.
Yeah, your mother.
Yeah.
So it was a joke in our company internet. One of our agents, like, actually, posited that he would include this disclaimer in communication with his mother about Sunday dinner, and I thought that was hilarious. And I may or may not have texted my mother with the same disclaimer.
Done the same.
It said something about not being held to previously agreed upon, dinner plans or something funny like that. But the truth is, like, that in its execution is ridiculous. And I will be the first one to say that I will not require my agents of that.
So what's the alternative?
To do that.
Because I agree, that's super clunky. I don't think it necessarily.
Well, the alternative is the fear, Gabe, is that you would inadvertently bind your client to a contract. So, for example, you're the seller's agent. Okay, and you send me a counter offer after I've presented you an offer on your listing. I get your text saying I just sent you a counter.
Yep.
And I first chance I get, I'm in between showings. I jam over to my email on my smartphone and I look at the counter. I fire you a text back, say got your counter. I'll call my seller or I'll call my buyer.
Okay.
Call my buyer, talk to my buyer. Present the counter offer. They say we'll take it. No problem. I've got another appointment. When I get back to the office, I'll send you the form to sign
get it signed up,
via electronic signature program of du jour.
Okay.
Okay. And before I do that, I fire a text back off to you, Gabe, and say, talk to them.
They're going to accept.
They'll take it.
Yeah.
Or they're going to accept.
Yeah.
They're going
looking for an
to,
email.
the words accept are more troublesome, but the way this is written, it could even say they're going to take it.
So how much of this ends up boiling down to semantics, right? Could you
There's a
argue
lot
that you
of
said they are going to, and since it's future tense, then you're not.
They haven't yet.
They haven't yet.
Or they'll take it.
Well, that kind of sounds like
They'll take it. They're going to accept. They've accepted. They will accept. There's a lot of semantics involved.
Right.
The point is, the answer in the affirmative with respect to an offer-counter-offer situation could inadvertently bind your client to something. Now, the 63-word disclaimer says we will never bind our clients to an offer or counteroffer or contract via electronic messaging.
Okay, yeah.
That's what it'll say. So, I mean, the truth is like, how do you coach that? How do you teach your agents not to make those mistakes? Well, here's what I told them. I said, your text messages should never, ever include the words accept or reject.
Yeah.
Never. I think that's pretty unilateral.
Just be careful with your text and if you're going to have conversations like that, which say like the acceptance deadline is 3 and it's 1 and you got to run to one more thing before you send them signatures. Instead of texting Jay and saying, hey, I'm going to be cutting it close, but they're going to accept, just be on the lookout for my email. Why don't you call and say, hey, I'm running into one more appointment and I'm going to send it to them. They're going to accept and be looking for an email. Just do it on the phone.
Yeah. I mean, it would, I think that argument could be made that that's binding as well, but like it's never going to be presented in writing to someone to argue. And here's the other point that I make, which I'm not going to, in the off chance that this ever happens, I'm not going to require this of my agents. But let's say this. I mean, it's never going to, it's very unlikely to be enforced, Gabe, but it will be used for leverage.
Sure.
Okay, so what do I mean by that? I mean that when your client that says we'll take it gets cold feet, doesn't sign the counter after you've already told the agent they'll take it, okay, and then they decide to exert pressure over you, essentially putting you at odds with your own client because you have now potentially bound them to a house that they don't want to buy. Okay, so that agent just has leverage. They don't like what has happened. They don't like the fact that they got their client excited for nothing because you told them something that your client's not going to follow through on. It's only ever going to be used probably for leverage. And that never works out well for you.
Correct. So if you wanted to make yourself safe in every situation just in case, and I know we could do hypotheticals all day on this, but what if you sent one blanket email at the beginning of each transaction and said, hey, all future electronic communications until at such a time that I tell you that it's no longer the case, do not constitute any, binding agreements on behalf of my client, and this includes email, text, all
How are you
these
going to
things.
do that?
I don't know. I mean, it's just as good as any other written disclaimer, right?
You're disclaiming to another agent
that all future communications electronically are not binding agreements unless otherwise stated in writing. Could you do that? And that way you don't have to send it in every text or send it every time you think of it or have to send it every day. You could, if it was brought up in court, could you say, hey, look, on January 13th, 2020, I sent this email, it was received, and it says that none of these communications...
Probably helps.
Okay. I mean, it's like you said, there's so many possibilities. The best thing to do instead of pontificating about like what specific verbiage you need is just teach your agents.
There's no one there's the Kentucky Real Estate Commission, the Greater Louisville Association of Realtors. Nobody's ever going to come out with a guidebook on what works and what doesn't. The truth is that even our disclaimer still may not protect you.
Yeah, I mean, it's just something you attach to an email.
Like who ends up presiding over that dispute if you ever get to a dispute? It's a judge. What if the judge thinks that your disclaimer is unlawful?
Then you're hosed. You can't go back.
You're absolutely hosed.
So
good luck. Good luck with that.
Yeah.
Good luck with that. So never use the word accept or reject unless you have an attached acceptance or rejection signed by your client.
Yeah, that's a good place to start.
That's a phenomenal.
And talk to your broker about what you're doing at the brokerage level next.
That's the problem though. A lot of brokers don't know how to do. Don't know what to do.
And what goes back to what we were saying. Just even knowing that these changes exist is like new ammunition in your arsenal.
I mean, there's a big discussion about Article 31 of the contract. I believe it's Article 31. Forgive me, it's new. I'm gonna thumb through and find it right now. Article 31 is the survival clause.
Right.
Basically just back referencing several items of the contract that now survive the closing date. Well, we had an agent the other day, a really experienced agent, tell us that they thought that this meant that the seller had to warrant the condition of the property for 12 months beyond because the survival clause lasts 12 months. So that, essentially, that the way they interpreted that was that the items disclosed on the seller's disclosure had to remain true for 12 months.
I don't see how that's possible.
Beyond the seller's ownership. It's not possible.
Yeah, you're no longer the seller.
The point is, and then they basically said they weren't going to accept our offer unless we struck the survival clause. Well, it just so happens that it was one of our agents trying to buy the property, and he really liked the house and really wanted it and thought it was a good deal, and so he did it. Because he's not really worried about the survival clause, and he's not really worried about the other terms surviving the closing. And, 4 weeks ago, before this contract was out, there wouldn't have been a survival clause, and several of the items didn't survive the closing, and he didn't care. He knows it more the prior way than he does this way.
True.
So he went ahead and bought the house, but the average consumer is not. So I think the lesson for today, more than anything, is to agents, hold your brokers accountable to giving you the information that you need when these types of changes happen. Get out in front of them, okay? Understand what it takes to remain relevant in today's market, and what you can do to create a competitive advantage for yourself because you know these things.
Yeah. Seriously, just knowing them is a competitive advantage.
It is
just knowing about them. I'm telling you, a surface level knowledge of these gives you one more thing in a listing appointment that you can spout that will make you look more educated. Now, it's important to get deeper than surface level eventually, but like there are tools that you can use at your disposal right now just because there are changes.
Well, yeah. I mean, okay, so let's talk a little bit more about what precipitates these changes. So, what specifically has our industry done to play fast and loose?
Yeah,
Okay.
where are those spots at?
Where are the spots? Well, I'll tell you where the spots are. The spots are teams acting like brokerages.
Okay.
Agents not identifying who they work for.
Specifically in advertisements.
Specifically in advertising. The majority of the reg changes are in advertising, and most of them reference compliant versus non-compliant advertising, specifically rooting in the agent portraying themselves in advertising as more important than the brokerage.
Okay.
Whether that be a team, whether that be an individual agent, the downplay of the brokerage identity and the playing up of the agent identity in advertising.
Or the team even.
Or the team even. Team or agent. Either one. Synonymous in this case. Okay? The fact that teams are not a thing. Let me say why teams are not a thing.
Okay.
You can go nowhere in the governing body of residential real estate transaction and find the fact that a team exists. There is no registration.
It's like a structure within your brokerage, and that's all it matters to, really.
Yeah. And so whatever the broker puts forth as requirements of the team is the only requirement.
Yeah.
The state regulatory agency does not require any sort of registration,
There's
identification.
no team leader's license that you have to
There's no
CE
team
for.
leader's license. There's no requirement to have so many years of experience or so many transactions of experience or additional education or nothing.
Yeah, you can anoint yourself a team leader.
You can
today
anoint.
if you want.
You can be a team of one.
Yeah,
I am the 1, 2, 3 team of one.
the 111 team.
I'm the 111 team.
Yeah.
No, and that's the thing, Gabe. You know, there are so many brokerage houses, big brands, small brokers alike, that are taking advantage. And this goes back to like all the way to season 1, okay, where we talked about is yesterday's brokerage broken. Find that episode if you haven't listened to us for long. The model has changed. You know, cloud-based brokerage, big tech, no brick and mortar, like internet brokerage, W-2'd agent.
With an emphasis on building your own team or individual identity.
I mean, I love teams. I'm a fan of teams.
Sure.
Everybody knows that. If you've listened to the show, you know that I'm a fan of teams. The problem is the majority of teams are really bad. The majority of team leaders are unqualified. The majority of advertising is non-compliant. The majority of brokers are absentee. Okay? Training and education is non-existent in our industry as a whole, and all of this hurts the consumer.
And so that's why the crackdown's happening.
So that's why the pendulum is swinging.
Yeah.
Okay? So contrary to what you may hear that regulation of small business is dead, okay, in real estate it's very much alive and well. It has been dead, and it has been on the table with the what are these things?
Defibrillators.
Defibrillate. Clear.
Yeah.
That's what we just did.
Yeah.
Okay. And, you know, it's going to prohibit the Sunshine Team, if you're watching on Facebook, the Sunshine Team, as I make a really large hand gesture with for the Sunshine Team's logo, and 1, 2, 3 real estate.
At the bottom, maybe. Or like you do the trick on your Instagram story where you make it small enough where you can slide it out of the story, but it's still actually there.
Anyway, that's not supposed to happen anymore.
Right.
The name of the broker is supposed to be featured as prominently as the name of the agent or team. Okay, and there's going to be a lot of people that are going to get their hands slapped over that. A lot.
Yeah.
So there's some other things, you know, like now video. I actually, you know, this podcast is relevant.
Yep.
Jay Pitts with Remax Premier Properties. If this is an advertisement, which
Well,
it's
in the
not.
video too, when your name shows up, it says Remax Premier Properties underneath.
Yeah, exactly. So if you're watching us on Facebook, but this is not an advertisement to consumers. This is
true.
This is a show aimed at real estate professionals. So you could make an argument this is an advertisement for brokerage services, but this is not an advertisement for real estate services.
Right.
Okay. So my point is if this were, I'm saying I'm with Remax Premier Properties, it would be good enough for me as the principal broker just to say my own name.
Okay.
Because they can go on the website at Kentucky Real Estate Commission and find Jay Pitts, the broker of Remax Premier Properties. Very
so
easily.
you're covered.
Okay. But Gabe Pruitt offering as a licensed real estate professional real estate services without naming Remax Premier Properties on an audio recording is non-compliant.
Well, let's talk about where this happens even more prevalently. Think about your professional Facebook page. What's the title of your Facebook page?
Yeah.
I know a lot of agents that are just, John Smith Realtor.
Yeah.
Or John Smith Realty Services, but nothing about the brokerage that they work at. It might be on the page somewhere, but it's not in the name.
Well, to be more specific, every individual page or post must be compliant.
Every one.
So anywhere your name can be visible and construed as an advertisement, the brokerage name must accompany it and must be of equal prominence. Okay, so let's go back. This is a different one, Gabe. So before we go in your direction, and we're going to wrap up soon, because I know this has been a pretty heady episode, but I want to make a couple of points. Something that's very new and actually quite progressive is on audio recordings, you must name the brokerage if it's an advertisement.
Okay.
Okay, because you don't have the ability to read it anywhere on an audio.
Sure.
Okay, so it must be Gabe Pruitt with Remax Premier Properties. On a video, it must be either presented in audio, Gabe Pruitt with Remax Premier Properties spoken word,
Yep.
or it must be visible on the screen, Gabe Pruitt Remax Premier Properties.
Does that mean within the video, or can it be when you
the
post it
video,
on Facebook?
overlaid?
You tag?
Well, we're going to go down the rabbit hole a little further.
Okay.
Because it must be in the video, but it must also be on the post.
Okay, so both.
So it has to be both. Okay, because there's probably, even with a pre-roll, there's a moment in that video where it's not present. Okay. But where if you, to keep every page and every post compliant, it must be in the post as well. Here's what I recommend, and this is a pro tip. My clients or my agents here at Remax Premier Properties know this. Use the check-in feature, the location check-in feature. It is always visible.
It's at the top.
On every post, and it's at the very top. Use that. Don't tag the company account. Okay, check in at. If your company does not have a Google address registered, talk to your broker today and make them do that. That's what is going to make it show up on all social channels. So Remax Premier Properties is there, and all you have to do is check in at. So I saw Tony Stanrod watching. Tony Stanrod is at Remax Premier Properties and then advertisement.
Yeah, and then your ad.
If you click the post, it will display in a different format. Tony Stanrod is at Remax Premier Properties.
Yeah.
Okay, you will be compliant. The biggest one that I see as an issue that has grown in prominence is Instagram stories. That's a big challenge, so you need to be careful there. But you can do the same thing there. You can drag and drop a check-in, location check-in, and it will show Remax Premier Properties or your brokerage on the screen. Okay?
And you made a good point today. It's better than tagging your brokerage, because if you've got an Instagram name like ours is Homes 502, that's not our brokerage's
That's
name.
not our brokerage name, and that would be non-compliant.
Yeah.
So pretty progressive is that it must be set. It's really funny that we fleshed out the fact that now our local board of realtors requirement of not advertising branded video through the MLS is now non-compliant as it pertains to the Kentucky Real Estate Commission's regs.
So how do you?
So you just don't. That's
Yeah,
the
I
answer.
mean-
Don't put a video on the MLS, agents. Whatever you do. I don't think very many people do it anymore because nobody sees it.
I mean, put it on social. Yeah.
Put it on your social, put it on Zillow by yourself, put it on Realtor.com by yourself with an upload, and you can use branded stuff on there. You just can't send it through the MLS because other agents have drip campaigns and such tied to that.
I see.
So anyway, neither here nor there. Going back to your personal Facebook page, I think it's okay. Somebody tell me if I'm wrong. I think it's probably okay to not have your brokerage name in your page title.
Okay.
So long as you are listed as
Member agent.
as your employer being Remax Premier Properties, as
That
long
makes
as
sense.
it's in your posts.
Yeah.
Okay, as long as it's in all of your content. So that's my thought. But you're right. I mean, social media posts, I was telling them today, I see more. I follow a lot of realtors. I'm friends with a lot of realtors, a lot of well-meaning people, and they never get punished for this stuff because they're well-meaning people that are not trying to deceive the public. They're not ne'er-do-wells, right?
Right.
They're doing a good job. It's very clear to the public that they're selling something. Nobody's being deceived by their posts, which is why they never get punished. But it's like the equivalent of pulling somebody over for speeding 1 mile an hour over the limit. The cops
Sure.
don't have time for that. Okay, where you're going to see problems is when your fellow agents start reporting you, because let me tell you, we're a petty group. Okay, that report button is too easy to click. Okay, and anonymous emails and all that, I mean, it is what it is.
It's so much easier to just be knowledgeable and avoid putting yourself in these situations in the first place. That way you don't ever have to claim ignorance, to get yourself out of a tough spot. No one wants to claim ignorance. So why don't you just know and avoid?
Well, that's very clear. Ignorance is not the best policy in this case.
No.
Ignorance is better than willful disobedience, but
It's like, I'm sorry, client, that this is making I had to get rid of all the ads I made for your house, but listen, I was just ignorant. So
yeah.
don't worry.
I don't think that goes over too well.
Yeah.
All right. So with that, it's the season of change. That's for sure. It's early in the year. Okay. This is where you have time. You have a couple of months. Okay. As you can tell, it's cold and flu season here with Gabe's sniffles.
Sorry, guys. I'll try to edit those out.
Sniffles and time to change your marketing efforts coincide.
Yes.
Cold and flu season is the time to change. Sorry.
I'm thinking of titles now.
Brutal connection.
Yeah.
I tried really hard, guys. Anyway, you got time. You got time before you get crazy busy. Okay? I hope for you that you've got 15 pendings already. But chances are, you're not as busy today as
warming up
as you will be in June. So let's get this stuff right so we can turn the page, not think about it, and go sell some real estate. Really? I mean, because if you're watching the show, listening to it on iTunes, watching it on Facebook as a member of our group, there's a good chance that I've met you, that I care about you, that I hope your business, I want nothing but the best for you. So let's do this. Learn the stuff. If you don't have an avenue at your brokerage to learn about this stuff, feel free to reach out to me. Send me a direct message. Talk to me. You probably got my cell number. Text me. I'm always happy to give you my opinion on this stuff. Take it or leave it. Yep. But the point is, you need to be prepared so you don't get yourself in trouble.
Exactly. And if for no other reason than that you have a leg up on your competition, I mean, it's worth knowing.
Absolutely. It's also the season of listing competition.
Ooh.
So set those landmines.
There you go. Absolutely. Well, that's all we've got for today. Of course, we're going to be back next week. We're in the group every Wednesday. If you're not in the group, make sure to reach out to myself or Jay to figure out how to get invited. You can't search for it. You have to be invited. So make sure you reach out if you'd like to be watching these episodes live. But of course, if you're listening right now on iTunes or wherever you consume this, make sure to leave us a rating. We really appreciate that. It helps us be more visible to agents in this market.
And if you don't like it, keep your opinion to yourself.
That's right. If you think it's like 4 stars, just tell us. Just text us.
Just let us know.
Yeah.
I mean, let us know what we can do to make it.
You don't have to post that.
To make it 5 stars. And also, I might ask a shameless request. If you've left us a review already, iTunes lets you leave more than one.
Oh.
Not sure if you're aware of this, but you can review the same podcast more than one time. So if you're feeling generous and you'd like to review season 2 and 3.
Oh, that's right, because they're broken by seasons. Yeah.
Feel free to write us a review on iTunes. Like I said, it makes us more visible, makes it easier for us to get our content to the people we want to hear it.
Absolutely. Well, that's all we got for today. We'll see you guys next week on Resource Real Talk about Louisville real estate. I'm Gabe Pruitt.
I'm Jay Pitts.
See you guys next time.